Well, I'm disappointed that amendment failed. I thought it was a very simple choice, whether or not we would let our own constituents, who we are employed as representatives of, decide for themselves what was best. I was surprised that I heard that this amendment would not benefit them, and I find almost no instances, in fact, I've never heard of an instance in my life where having individual freedom of choice did not benefit someone. Anyway, I'd like to put something else on the record, too, and that is it was stated early on in this debate that this is not binding. And while the written estimate is stated as not binding in the first section of the bill itself is very binding on employers. I'm reading through section 1 of the bill, and it says the employer shall, the employer shall, the employer shall, the employer shall, I think 7 times. And that strikes me as binding. There are many requirements placed on employers in this language. Also, it says on line 188 of the bill that any person aggrieved by a violation of any provision of this section, which is the section that has all of those binding shalls, the labor commissioner, the attorney general, or any entity a member of which is aggrieved by a violation of this section may bring a civil action to recover damages, and so on. I would say that is very binding, Madam President. If an employer fails to follow the requirements in this bill, they may very well end up in trouble with the labor commissioner, the attorney general, and in a courtroom being sued. And I think that not only has a chilling effect on the way businesses operate in this state, but it certainly is binding. I wanted to also just touch base on some of the testimony that we heard. There were certainly people in favor of the bill, including the representative of the Communist Party, which I found interesting. But what is also interesting is the number of folks that came and spoke in opposition, and the many, many comments they made regarding situations that are not contemplated by this legislation. Even the representative of the Connecticut Conference of Municipalities, the lobbying organization that speaks on behalf of the major cities in our state, opposes this bill because it would limit the flexibility that local officials have for the municipality. So clearly, if local officials are bound in some way by this language, we might end up having to pay employees for not working, et cetera, all of which is a burden on taxpayers. The Connecticut Hospital Association, even though I know this bill has been modified in some respects and does not necessarily cover employees in the health field, there are still many, many hospital employees that are affected. And those folks could be under similar unprecedented situations. If there was a catastrophe, God forbid, or something that affected the amount of traffic in a hospital. The Restaurant Association has already been addressed, and I think my colleague did an immensely good job of explaining all of the intricacies of working in a restaurant or bar situation, and just exactly how those employees operate, and that they may, in fact, want to give up certain shifts and exchange them with others because they're looking to drive up their tip wages as opposed to being on when it's slow. Not to mention that many, many businesses, restaurants at the shoreline, for instance, might be subject to more or less traffic based on weather. If there is a ball game in town that night, who knows what is affecting the traffic that any of these businesses face, and that can change at any time, and employers need to be able to adapt to. There was lots and lots of testimony from folks that work in the home care industry as well as in nursing homes. And I don't doubt that that is what led to the change in policy that is before us. But it makes one wonder, you know, why is this policy good for some people in some industries and not for others? If it's such a good policy for workers and we should make sure that all workers have these protections, then why are we limiting this bill in any way, shape, or form, I would have to ask the proponents. Why is only 7 days good when 14 days would be better? Why is it only going to affect these larger businesses? What about small businesses? What about the employees that work for them? Are they not eligible for the same type of policy? I really believe, Madam President, there is not so much confidence that this is a good policy when we have to start out like this. And make no mistake, Madam President, the goal is actually to make it apply to every business across this state. We've seen this many, many times. Policies that have been enacted saying, well, it's only 250 employees and over. Well, the next time around, it's less. We're watching that happen with paid sick leave. I have the testimony from the Connecticut Retail Merchants Association. I just love the commentary in their testimony. I thought it was spot on. It's some things I might say myself. Laws should encourage a collaborative approach between the employer and employee in designing schedules so that available hours or shifts can be discussed freely. This bill discourages that. It prevents an employer and an employee from having a conversation from one another on this subject because you're creating what I would consider to be an adverse relationship. And it's something that's quite common in this building, this constant desire to pit employees and employers against one another. That's not the way I was brought up, Madam President. I was brought up that when I work for a company, it is in my best interest to help that company succeed because that's how that company is going to profit and be able to hire more people and give me a raise potentially or a promotion to a different position. That's how economies work. And that's what's lacking in policy when this body proposes to manage the citizens and businesses it knows nothing about. They go on to say that scheduling is a complex process. It's built around the availability of employees, something that was not addressed in the opening discussion of this bill. It was only about making the employers react. And they do, in fact, because they are already at the will of when employees are available. It says, when formulating a schedule, there are loads and loads of other data points that are crucial. Sales forecasts, delivery schedules. Did anyone contemplate that deliveries might affect these businesses and when their staff might be necessary to be there to stock shelves or to do whatever else might be associated with that delivery? Meal and rest breaks, payroll hours, promotional events, anticipated swings in customer traffic. Not to mention unanticipated inclement weather, public events adjacent to or surrounding a store location, public transit issues. These are all factors that will weigh on a business and how they schedule their employees that this bill has no consideration for. It does not contemplate, it does not care. It is simply words on a paper that you must follow. They go on to say that rigid scheduling is an anti-business and anti-employee mandate. And that's what I would like to finish my comments with in a moment. That this is not just anti-business, it is anti-employee also. They finished their testimony by making a point that there are unintended consequences that could bring additional adverse impacts. Employees may need to offer fewer hours, and that compliance with these laws can have an impact on store culture, limiting open communication, and that every company is unique in how they operate. And that uniqueness is what lends to creativity. And that creativity is what lends itself to success. So many policies that we create in this building, whether they are economic or otherwise in nature, have a tendency to tell people to conform and do it our way. When in fact, the best solution is to let different municipalities try different things, to let different businesses try different things. It is through that experimentation that new things are created and new products and new ideas evolve and grow our economy and make us more successful. But at the end of the day, Madam President, I'm going to vote no on this bill simply because I believe that this is a policy that unnecessarily puts this body, this government, again, where it does not belong, which is directly between an employer and an employee. Employment is a voluntary relationship. Does everyone understand that? That means that when an employer hires someone, they're doing it because they want that person to work for them, and they're willing to pay them for the job that they are hiring them for. And when a person accepts the job, it is because they are aware of the terms of employment and have accepted them. It's very simple. The two parties decide whether it's a good fit, and if it's not, they don't make the deal. What is the state's role in that agreement? I would say it doesn't have one. I mean, certainly historically, the state has stepped in to do things like prevent child labor, etc. But Madam President, we are a million miles from there. We are here talking about stuff that really has nothing to do with protecting anyone. It is just us sticking our nose where it doesn't belong. Again, what exactly do the people in this room know about running the businesses that operate in our state? Restaurants, yes, we have a couple of restaurateurs. We have people that are in hospitality industry. But I'm a real estate agent. I know that other people who serve in the legislature are teachers, doctors, many folks are lawyers. What do we know about managing a Dunkin' Donuts and dealing with shift scheduling for the employees there? I would never claim to know the first thing about it, which is why I am extremely uncomfortable saying I would support a bill that's going to tell them how to do it. It's almost absurd that we would be doing something like that. We work for our constituents, not the other way around. We're not their managers, and none of us should be managing the Dunkin' Donuts in our town. Our primary job is to protect the rights of the people we represent. I heard a fellow senator say the other day something very surprising to me. They said it's our job to tell people how to act. It was on an entirely different subject, but I was like, no, that's not our job. Our job is not to tell people how to act. Our job is to listen to our constituents and protect their freedoms. This policy before us is bad policy, Madam President. It interferes with free people making their own decisions. I'm so disappointed the amendment failed before because it was a simple choice. Do we want people to be able to make their own decisions even if the bill passed? That would have made it 1,000 times better because it would at least said that in cases where people are entering into an agreement with open eyes, they can do that. And we don't need to put this bill upon those free people who have a good idea what they want. But no, that amendment fails, and we're going to force everyone to follow this law whether they like it or not. Madam President, I will not vote for policies like this anymore. They are destroying the economy in this state, and they are making us less free. And people are noticing. People are noticing what is happening with our state government taking over and putting too much on the individual citizens and businesses. And I'm afraid it's hurting us, and it's going to hurt our future even more. I encourage my colleagues to put a stop to it today and vote no on yet another anti-business policy. Thank you, Mr. President.